Okay, so before I get started, I just want to let everyone know that this presentation was pre-recorded before. I've done this workshop a number of different times in the past, and the last time that I did it was in December of 2020. And a lot of it was right in the middle of COVID. So I really have not done any of these in person since then, but I would like to do that in the future. So just letting you know, if you hear some information in here that refers to 2021 or the pandemic, it's because I am playing a seminar that was previously recorded, but the information is the same. The information has not changed. And after the, and if you have any questions, please let me know and I will be happy to answer them. But I'm going to go ahead and get started. I'm going to share my screen with you.
So I want to thank everyone for tuning in to this seminar. Times in the past, pre-COVID, in person, in conjunction with Andrew Green. And I had gotten a lot of questions over the past couple of weeks about this process, and I just wanted to be able to streamline it so that I could actually put information out there for everyone that would be available to share. So the first thing that I want to touch on in getting started is actually talking about the new law that just took effect last month. So I am going to share a short presentation with you. It's not anything fancy. I really was not trying to do anything fancy with this. So let me share my screen so that everyone is able to see this. Okay, so you should see something that says record restriction and in parentheses expungement. So basically, as far as the legalities go, the courts do not use the word expungement anymore. It's referred to as record restriction. And the reason why it's referred to as record restriction is that your record is not exactly expunged. When it is called record restriction, it means that your record is restricted to only law enforcement being able to see your criminal history. No one else outside of that. So it's not really being erased completely from it. It's only since that law enforcement is the only agency that has access to your actual record. Okay. So let me go into this new law that just came about in January, because for some people it was really confusing as to exactly what it meant. So I'm going to go over that now. So Senate Bill 288, which went into effect January 1st of this year, was expanding restriction and sealing of convictions. It was passed through the Georgia legislature. And it amends the original one to provide for restriction and sealing of certain misdemeanor and felony. So it essentially removed the age limitation for most offenses by allowing an individual to petition the court to restrict and seal up to 2 misdemeanor convictions from their record in any offense that has been pardoned, as long as it was not a serious violent felony or sexual offense. And I'll go down the list of things that do not apply, that there are no exclusions for. As I said before, law enforcement does retain access to the records. So no one in the public arena would be able to access them, but law enforcement would still retain access to your records under restriction and sealing, okay? And it also provided for liability protections for employers who hire individuals with criminal history to help them engage in second chance hiring, okay? So let me go back and show you the list of the serious felonies and other sexual offenses so these are the ones that are excluded under the pardoned felony offenses: murder or felony murder, armed robbery, kidnapping, rape, aggravated child molestation, aggravated sodomy, aggravated sexual battery, aggravated assault with intent to rape, false imprisonment, sodomy, statutory rape, child molestation, enticing a child for indecent purposes, sexual assault against persons in custody, and sexual exploitation of children. So there is no way for you to get a pardon under these offenses, which would also not allow you to be able to get record restriction under those offenses as well. So let me go back. Trying to go back to also the other felonies. Okay, so I'm sorry, misdemeanor offenses. So the excluded misdemeanor offenses include family violence, simple assault, family violence, simple battery, and family violence battery, family violence stalking, violating a family violence order, child molestation, enticing a child for indecent purposes, improper sexual contact by employee or agent, public indecency, keeping a place of prostitution, pimping, pandering by compulsion, sexual battery, obstructing or hindering persons making emergency telephone calls, peeping toms, all offenses that are related to minors, theft in violation of Chapter 8 of Title 16, unless you were convicted of shoplifting or refund fraud, DUI, and all of the traffic offenses. So those are the felonies and the misdemeanor offenses that are excluded under the pardon and the record restriction. Because some people think that, oh, I can just go ahead and get it just because I have a conviction. That's not necessarily true. There are offenses that you are not able to have pardon or even go through the process of record restriction. So let me just go ahead and put that out there. So let's talk some more about record restriction. So some people ask, does record restriction happen automatically? So if your arrest is not referred for prosecution, it will be restricted from your GCIC criminal history record automatically after a period of 2 years for misdemeanors and 4 years for most felonies, and 7 years for serious violent and sex-related felonies. But there are some caveats to that. But if the record is automatically restricted and a later disposition entered does not qualify for restriction, then the law requires that the record be unrestricted by GCIC. So there are a lot of exclusions to the rule, if you will. So some people ask, if they didn't have a conviction, why is the charge still under criminal history? So if you're arrested before July of 2013, the record remains on your official criminal history unless the charges qualifies for a record restriction and you actually complete the restriction application process. If you arrested after July 1st, 2013, and the charges qualify for restriction, the arrest will then be restricted by GCIC when the disposition is entered into the GCIC database by the prosecutor or clerk of court. So the records of the arresting agency will be restricted within 30 days of the entry of the disposition into GCIC's database. So, however, regardless of if you were arrested before 2013 or after, if you ever had a case that was placed on the dead docket, you would have to wait 12 months from the date the case was placed on the dead docket to file an action in Superior Court for a restriction. So I did get a lot of questions about that, and I just wanted to clarify about the situations with the dead dockets, because there were a couple of people that asked me that. And so when we're talking about Georgia law, we're talking about how it only allows for restriction in 3 situations, okay? For non-convictions, and that's generally cases that are closed without conviction that qualify for restriction. And that can include charges that were closed by the arresting agency, if they were dismissed, if there were no process, and those not presented to the grand jury or no bill by the grand jury. However, verdicts of not guilty and vacated or reversed convictions are also eligible for restriction. Now, let's talk about the non-conviction exceptions. So the restriction would not be available after indictment if a charge was dismissed because you pled guilty to another charge in the case, you were involved in a pattern of criminal activity prosecuted in another jurisdiction, or the prosecution could not use important evidence against you, meaning your evidence was suppressed. And also if you had some type of form of immunity, okay? If there was ever a situation where an individual was acquitted, but within 10 days of the verdict being presented, the prosecution convinced the court to not restrict, or if there's a situation where it's determined that the jury was tampered with or there was any type of judicial misconduct, that's one of the situations where restriction would possibly be available. Any type of situations with youthful offenders, any type of convictions that occurred before an individual was 21 years old can also qualify for restriction. But in that case, the individual must have completed their sentence, and in the 5 years before requesting restriction, they must not have had any additional charges other than minor traffic offenses. There are some exceptions to a youthful offender being able to restrict. DUI is one, reckless driving, aggressive driving, any type of fleeing or attempting to elude, if they cause serious injury by vehicular homicide, theft, but that does not include shoplifting. Anything like child molestation or enticing a child for indecent purposes, pimping, keeping a place of prostitution, pandering by compulsion, masturbation for hire, giving massages in a place used for lewd sexual acts, sexual battery, sexual assault by persons with supervisory disciplinary authority, sexual exploitation of children, any type of furnishing obscene material to minors electronically, any type of obscene phone contact with a minor, or computer pornography. In that case, the youthful offender would not be able to apply for record restriction. So if someone is charged with a felony but convicted of an unrelated misdemeanor, you may be able to have a felony charge restricted if it was closed without conviction and you were only convicted of an unrelated misdemeanor offense in that case. But it will be up to the court to determine whether the restriction is appropriate, considering the harm that the record may be causing you, if it's affecting you getting a job, any type of housing or licensure in a professional capacity. But you're not eligible for restriction if you were convicted of a lesser included offense of the felony charge. So that's where it gets a little bit tricky. I had also been asked before if someone can have their whole criminal history restricted. And the Georgia law does not allow for that. You have to apply separately for record restriction for each arrest that is on your criminal history. So you wouldn't be able to do it for one record. I'm sorry, for your whole record. You would have to do those individual cases in your criminal history. So I'm trying to think of what, oh yeah. The other thing I've been asked about is pretrial diversion programs. So if charges are dismissed after you successfully complete a pretrial intervention or diversion program, you do qualify for restriction. If the court placed your case on the dead docket at the time you were ordered to complete the program, you'll need to file an action in Superior Court for restriction. But if you completed a pretrial intervention or diversion program, your record does qualify for restriction. So just remember that if anyone has any cases that have been placed on a dead docket, you have to ask the court to present the action with the case so you can move forward to have it restricted. And if anyone has been denied restriction in the past, you can reapply under this new law. So if you were denied in the past and you have not applied under this new law that just took effect in January, you can reapply under this new law. Also, I want to say that for everyone that has tuned in, to get your record restricted or to apply for a pardon or your restoration of civil rights or your right to carry a firearm, you do not need an attorney. You do not need anyone special to fill out the paperwork for you. You can do this on your own. It will be somewhat time consuming. And I'll talk about exactly what the process is now for record restriction. So let me go ahead and go back. Okay. So as I was saying before, you have to petition the original sentencing court to restrict and seal the record of a misdemeanor offense 4 years after sentence completion if you have not been convicted of any new offenses within those 4 years and do not have any pending charges. As we talked about before, in the list I showed you, certain misdemeanor offenses are excluded. And if an individual has been granted a pardon by the State Board of Pardons and Paroles, they may petition the original sentencing court to restrict and seal the record of that conviction. So if you have applied for a pardon and received a pardon, you can still apply to have that record restricted and sealed. If, as an individual, you received a pardon for a serious violent felony or sexual offense, then you would not be eligible for restriction and sealing. okay? So there are some cases where you would not be able to do it. So let's talk about the process. For misdemeanors, a petition must be filed in the court that originally handled the case. So it's very important to remember so you don't waste your time or money getting different copies of different things and mailing things. You have to remember that the petition must be filed in the court that originally handled the case. For felonies, the individual must first obtain a pardon and then file a petition in the original court. So with this process for felonies, you must receive a pardon first and then file a petition in the original court. And in deciding whether or not to grant the petition, once again, the court will consider the harm to you, whether it's affecting your ability to get a job, whether it's affecting your ability to get housing, as well as I said before, professional licensure, versus the public's interest in knowing about the conviction on whether or not it should be restricted and sealed. So please do keep that in mind. I'm not sure about the percentage of applications that are successfully approved for record restriction, or as we used to call it, expungement. I do know for pardons, they normally approve about 38% of those applications, but you have to keep in mind for both processes, they do take time. Pardons, normally the turnaround can be up to 9 months. Right now with COVID, I'm not really sure about the actual time frame. Excuse me. I'm sorry. With COVID, I'm not really sure about the current time frame with the record restriction. But from my understanding, because you're dealing with the actual court, it normally takes a little bit less time than the pardons. Okay, so let's go into pardon and restoration of rights. As I said before, normally about 38% of these petitions are actually approved. I'm sorry, guys. I'm going through it with my throat right now, but about 38% of these petitions are successfully approved. And there are ways to give you a better chance of having yours approved, and I'll talk about that shortly. So let's talk about pardons. And I want people to understand the difference because sometimes it's confused. So let's go through this about understanding the difference. So a pardon is an order of official forgiveness and is granted to those individuals who have maintained a good reputation in their community following the completion of their sentences. The pardon is an official statement that will be attached to the criminal record that states the state of Georgia has pardoned the crime. Please understand, it does not expunge, remove, or erase the crime from your record, but it may serve as a means for the person who applied to advance in employment or education. So it will not expunge or remove anything from your record. It will be attached to your criminal record as an official statement saying that you have been pardoned by the state of Georgia, okay? Next, we're talking about restoration of civil and political rights. This is an order restoring a person's civil rights, which are lost in Georgia upon conviction. These include the right to run and hold public office, to serve on a jury, and to serve as a notary public. Something that's extremely important to remember, and I've talked to a number of people who did not know this, your right to vote is automatically restored upon completion of your sentences. Therefore, you do not need to submit an application to have your right to vote to restore it because it's automatically restored once you complete your sentences. However, you do need to register to vote. Okay. And with restoration of civil and political rights, you have to have completed all your sentences at least 2 years prior. For a pardon, it means 5 years prior, and you cannot have gotten into any additional trouble after that. When we're talking about the restoration of firearms rights, it's the same guidelines for the pardon, meaning you must have completed everything 5 years prior and cannot have gotten into any additional trouble during that time. However, you must complete a personal interview and submit 3 letters of recommendation. So solely for the restoration of firearms rights, you would still fill out the same application as the pardon, but you have to go a step further and complete a personal interview as well as submit 3 letters of recommendation. And the restoration of firearms rights can also be excluded in some instances as well. More so in any type of instances of family violence or domestic violence, those rights would not be restored. Okay, so eligibility for pardons. You must have completed all sentences at least 5 years prior to applying. You must have lived a law-abiding life during the 5 years prior to applying, and you cannot have any pending charges. All fines and restitution must be paid in full. Okay. So I'm going to stop this share right quick and share something else with you from my screen. And that is the actual application, because I want people to see what's actually involved. When you submit. So I'm going to share my screen with you again. Okay, so this is what the actual application looks like. From the pardons and paroles. So the first is a waiver to release information for the applicants being considered for restoration of firearm rights. Okay, so as I said, this is the same. Hold up, let me try to go back. This is the same. Okay. See if it'll let me go back for a second. Hold on. Okay, now, because I got to get ahead of myself. And I was like, I know that's not the beginning of it. That's not the beginning of the application. But anyway, so this is what the first page of the application looks like. It says application for pardon and restoration of rights. So you would check the appropriate line here for what you're actually applying for. If you're applying for your restoration of civil and political rights, you would check that line. If you're applying for a pardon, you would check that line. or the restoration of right to receive, possess, or transport in commerce a firearm, you would check that line. And then there's a pardon exception, but that is normally for other offenses that I really won't get into because I know no one on this particular call has those issues. But you can apply for a pardon and you can apply for the restoration of your right to carry a firearm at the same time. You do not have to do separate applications. You can apply for those at the same time, okay? So here's some additional information to remember, and I'm going to make sure that I make that a little bit bigger. So if you look down here where it says additional information, it says the State Board of Pardons and Paroles cannot pardon federal offenses or offenses that occurred in other states. They're specifically limited to the state of Georgia, okay? They cannot restore firearm rights to a person who was dishonorably discharged from the armed forces, cannot expunge, again, remember that, or remove from your record any charges or convictions you have received, nor can the State Board of Pardons and Paroles seal your records. That is exclusively limited to the courts, okay? A pardon may only be granted for a state of Georgia conviction. We already talked about how your right to vote is automatically restored upon completion of your sentences. This SBPP will process your application for pardon if you have dead docket cases on your criminal record. However, the SBPP does not have the authority to pardon dead docket cases. So you'll have to seek a disposition on those cases through the courts, which originally brought the charges. And if you are convicted on the charges, you will need to apply for another pardon through the SBPP once you meet the eligibility requirements. So the SBPP will not process your application for firearm restoration if you have dead docket cases on your criminal record. You will need to first seek a disposition on the cases through the court, which originally brought the charges. So that is what I was referring to before when I was talking about there needs to be actions taken on the dead docket cases, if anyone has any of those, in order for them to be able to move forward with the process. And if you have time expired restriction cases, which means that there was a restriction put through, but only for a certain amount of time, maybe 5 years, 10 years, 15 years, 20 years, and you'll need to obtain those dispositions on each before the SBPP can consider your case. And the bottom is about seeking pardons for sex offenses and all the other stuff, but we don't need to worry about that. So with this next page, it asks you for different demographic information, your status, whether you're married, divorced, separated, or single. You would need to provide that information to them. If you have minor children and you do not have custody of them, you need to also put in there who you pay child support to, whether your payments are current, and if not, what is the reason for your failure to pay those payments, and if you made any agreements to satisfy the obligation. I would encourage people when you're filling this out to be as honest and truthful as you possibly can, because if there is a lie in here somewhere, they will more than likely find it. So just make sure you're being as transparent as you can possibly be. Then it'll also ask if you do have any children under the age of 18 living in your home, and then you'll need to list their names and ages as well. So they'll also ask for your information as far as your education, any type of military service you want to put there as well. And if you do list it, you are required to provide them with a copy of your DD-214. Your DD-214 is really easy to obtain now because everything is done online, and it takes maybe a couple of days for it to come back. So that should not be an issue. And it'll also ask about your employment, your current employment and previous employment as well. You're also able to attach a current pay stub or a W-2 to verify your employment. And if you're receiving disability, you can attach proof of that as well. It also asks about any type of substance abuse and mental health history. Let's say that you had any type of alcohol or drug addiction. This is what you would put here. They want to know more about that because some of the older cases that have been prosecuted back in the day, when they weren't really trying to offer treatment to people that were on things like crack cocaine and stuff like that, they just decided to throw them in prison for these extensive periods of time, not understanding that some of these people had real addictions, and the drugs that they had on them were personal drugs that they were not really trying to sell or traffic or anything like that. So this is one of the reasons why they asked that particular question. So we go on. Then they also ask for some civil and financial information. If you've ever been a party in a civil lawsuit, do you have any pending judicial administrative proceedings, whether it's federal, state, or local government, and they want you to provide that information as well. And this part here is extremely important. So here is where you give your version of the story, your version of the events that transpired that led to your arrest. They want you to do it in your own words, give them the factual circumstances of all the offenses in which resulted in conviction, for which you're applying for the pardon for, okay? Within that, you're also expected to attach all of your dispositions to the application. So they will have those, but they want to know what your version of the events are. We know in situations dealing with law enforcement that, hey, we know that they are not always truthful. We know that for a fact. So this is the board wanting your version of the event that led to your conviction with the offenses that you were arrested for. And then this is very, very, very important. This is the justification for your pardon consideration, okay? You're going to explain your reason for applying for this particular pardon, or if you're doing a restoration of firearm rights as well too. You want to tell them how your life has changed, whether you have not gotten into any trouble for years, whether you become a productive member of society, started your own business, do tons of volunteer work in the community, do lots of work in your church. They want to hear those things. These are the things that are going to tell them, yes, I made a mistake, or, yes, I was doing some things that I wasn't supposed to be doing, but I'm not that person anymore. You also want to tell them, how it's affecting you. As I said before, if you're having trouble getting a job, if you're having trouble getting housing, if there's some type of professional license you need to pay, that's hindering you from doing that, this is where they need to hear those stories and hear how it's affecting you so that they can weigh, whether or not they should give the approval. And then this would be your certification personal oath saying everything that I submitted is true. And then you need to have it notarized as well. It must be notarized before submission. So this is the waiver to release information. So as I said, the reason why you need to be truthful is even though you're submitting your dispositions to them, they are still going to do their own background investigation. That is why it's very important for you to be upfront, transparent, and truthful when you are submitting your application, because they're still going to make sure that what you're presenting to them is accurate. In this one that we jumped ahead of ourselves to get to, this is the waiver to release information for anyone that wants their firearm rights restored. So this would also be an additional step to include. And as I said before, you have to do an actual interview, a personal interview, and you would also have to submit 3 letters of recommendation if you were applying to have your firearm rights restored. Okay, so let me go back to where I was before. And one of the things that I want to show you is what a personal statement looks like that you can submit with your pardon application. I'm going to show you a sample. Okay, so this is a simple personal statement for your pardon application. So you're basically submitting it to the Board of Pardons and Paroles. It says, my name is blah, 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 and I'm requesting a pardon due to the progress I have made in my life. I realize that I made some bad choices in my life, but I have worked hard to blah, blah, blah. Okay, so anything that applies to you, how your life is different, is just basically telling you to take responsibility for your actions and talk about how you have changed and put that behind you. Okay. The convictions on my criminal history occurred more than 10 years ago when I was battling alcoholism and addiction. This is probably not applicable to anyone that's tuning in right now, but this is just a sample statement. But you still want to speak to your personal circumstances and your story. And as I said before, you need to show how this is affecting you personally. It has been very hard for me to find a job or housing or whatever the situation may be. And I hope a pardon will help. Thank you for your consideration. Okay, so this is just a basic template and a sample personal statement that you should include with your pardon application. And also, the thing that helps, as I said, the thing that helps for approval is that sample statement and letters of recommendation. So when you're thinking about letters of recommendation, it could be your current employer, it could be the minister at your church, it could be your professor or instructor at school, it could be someone from an organization that you volunteer for, it could be a friend that you've known for years, it could be one of your city commissioners or county commissioners. Getting one from a city or county commissioner definitely holds a lot of weight. So whenever you do decide to go through with the process, you want to contact those people who are responsible for your district in order to get a letter of recommendation. I know for sure that Rotten McCord has been really, really good at providing letters of recommendation for people who want them. He'll put it on official city letterhead and give it to you to be included with your application. He is really, really good in making sure that he helps citizens that way. But with this sample letter of recommendation, this is just similar to something that can be written. I'm writing in support of blah, blah, blah's application for pardon. I have known them for however many years, you know, whatever that relationship was, and, you know, how they personally know you. And, you know, that you admitted to the mistakes you made, you changed, just things that they know about you that shows that you're not that person anymore. Okay. And if they can speak to any type of situation they witnessed where you're having trouble with getting something that you need done because it's affecting your life in a certain type of way. Okay. So I just wanted to show those because the sample personal statement and the letters of recommendation are what, if you include those, you're much more likely to get an approval than if you don't. Because this is showing that someone else can speak to your situation. And especially with if you're applying for your firearm rights to be restored, that would be required, period. You would need 3 letters of recommendation for that to have your firearm rights restored. Okay, so I know I went through this kind of quickly. So if anybody has any questions, please let me know. No questions so far? Okay. Well, the last thing that I want to say is, as I said before, when you're applying for either your pardon or the restoration of civil rights or the restoration of your firearm rights, you're required to submit your criminal history record. You need the certified sentence sheets for the dispositions that are not noted on your criminal history. And then you have to send a self-addressed stamped envelope, normally the 9.5 by 4 1/8 size envelope, and then send it to this address. So none of this is done electronically. Everything is done on paper. But it's very important that you fill out all the information correctly. You fill out all the information thoroughly. You're being extremely truthful and making sure that you include your personal statement and the letter of recommendation as well. Any questions? Okay, let's see it.
Okay, so I'm gonna stop it there, just to see if anyone had any questions they like to ask. because this is actually the end of the presentation. Okay, so if no one has any questions, if you like, I could uh I could email you this particular slideshow so that you have the information with you whenever you decide to apply. And I'm also going to post this recording if you want to refer back to it. But if you want me to email you the actual presentation, if you could put your email address in the chat box, and I'll make sure that I email this presentation to you. Okay, Miss Welch, I have your email address, and I'll make sure I send that to you today. If there are no further questions, I hope everyone has a great rest of their Saturday and be safe and try to stay dry.